Welcome in, everyone. We are so glad you joined us today for this custom deep dive.
Yeah, really glad to have you here.
And our mission today is to unpack a highly specific, deeply intriguing mechanism within the justice system that, well, it creates a truly bizarre gray area.
It really does.
Because, we typically view the law as this strict binary system, right?
Yeah.
Designed to produce one or two definitive outcomes.
Guilty or not guilty.
Exactly. And individuals either found guilty or they are found not guilty. It's the absolute bedrock of how we understand justice. But the legal documentation we're examining today introduces a concept that completely shatters that binary.
Shatters it completely.
It's one of those administrative quirks that sounds almost fictional. Until you realize it is an actual functioning part of the legal machinery.
And actively affecting real cases and real assets.
Right.
It challenges a lot of the fundamental assumptions we make about how the law operates, particularly regarding finality.
Yeah, we expect an ending.
We expect the courts to provide a resolution. When the state brings the full weight of its resources to bear against an individual, we expect the conclusion to be a definitive ruling.
Right, a verdict.
But this particular legal mechanism introduces a state of permanent suspension. It's a concept that forces us to reevaluate what it actually means to have an accusation leveled against you. And more importantly, what it means for the state to act upon an accusation that has never been formally resolved in a courtroom.
Okay, so to set the stage for you, imagine a scenario where the authorities have investigated a crime. They've gathered the evidence, they've built a case.
They've done all the legwork.
They have the paperwork, they have the proof, and they bring it to the court ready for prosecution. The judge reviews the material and explicitly agrees that, yes, there is enough evidence here to warrant a trial.
The threshold is met.
But then, instead of proceeding to a jury, instead of seeking a verdict, the judge simply decides to put that charge in a drawer and close it.
Just files it away.
No trial, no jury, there's no verdict whatsoever, and crucially, there is absolutely no admission of guilt from the defendant.
Not at all.
The charge is just left sitting there, suspended in time. Okay, let's unpack this.
The mechanism you were describing has a very specific designation. It's called allowing a criminal charge to lie on file.
Lie on file.
Right. But before we get into the intricate mechanics of how this operates, we must establish the strict geographical and jurisdictional boundaries outlined in our sources.
Yeah, this isn't everywhere.
No, this is not some universal legal loophole found in every Western democracy. It is a highly specific legal term applicable exclusively within English law, which means it governs the jurisdiction of England and Wales.
So we are operating squarely within the framework of English law for this discussion.
Now, the mechanics of how a charge actually ends up lying on file, it requires a very specific set of circumstances.
Very specific. The documentation outlines a precise two-part test that must be met before a judge can authorize this kind of legal limbo.
Okay, what's part one? The first hurdle is evidentiary. The presiding judge has to explicitly review the case and agree that there is enough evidence for the prosecution to proceed.
So the court is formally acknowledging that the state has met a preliminary threshold.
Exactly. That first requirement is critical because it separates this mechanism from a simple dismissal.
Oh, right. Because a dismissal is when they throw it out.
Yes. A charge isn't allowed to lie on file because the prosecution's case is weak or because the evidence is circumstantial or flawed. The judge is actively validating that the prosecution has brought forward a substantive case, one that could legitimately be argued in front of a jury.
So the evidence is solid.
The evidence is solid, but it is the second part of the test that introduces the pragmatism.
Okay.
For a charge to lie on file, the court must also determine that it is not in the public interest for the prosecution to proceed with a trial.
Okay, and that second prong is the pivot point where this entire concept rests. Because if the judge just verified that the state has solid evidence of a crime, the immediate logical question you'd ask is, why wouldn't it be in the public interest to hold a trial?
It seems counterintuitive.
Completely.
Yeah.
The instinct is that pursuing proven crimes is the very definition of the public interest. So, looking at the source material, the core rationale for this trade-off comes down to the broader context of the defendant's actions.
Right.
Typically, a charge is allowed to lie on file because the defendant is already facing other charges, and crucially, they have already admitted to those other charges.
Which are usually of a much more serious nature.
Exactly.
It is a profound exercise in judicial pragmatism. The court is looking at the totality of the defendant's criminal liability and making a calculated administrative decision.
Basically zooming out.
Yes. Consider a complex, multi-layered criminal prosecution. A defendant might be facing a massive indictment for organizing a vast, multi-million-pound drug trafficking syndicate, or maybe executing a highly sophisticated corporate fraud that took years to unravel.
Big, heavy stuff.
Right. They concede to the overwhelming evidence on those major counts and admit guilt. But alongside those massive offenses, the prosecution might also have evidence of a peripheral, much less severe, crime.
Like a smaller side hustle.
Perhaps a minor regulatory breach, or a low-level property offense committed on the periphery of the main conspiracy.
So in that scenario, the justice system is essentially conducting a massive cost-benefit analysis.
That's exactly what it is.
The court knows the defendant is already going to receive a severe, lengthy sentence for the major crimes they just admitted to. The prosecution has the evidence for the minor charge, sure, but organizing a whole separate trial for it.
Summoning a jury.
Utilizing court time.
Paying for the prosecution's resources.
It would be a massive expenditure of public funds, and ultimately, securing a conviction on that minor charge wouldn't really materially alter the length of the defendant's incarceration or the overall outcome for public safety, right?
The punishment for the primary offense completely overshadows the secondary one. The administrative logic is actually very sound. The court system is chronically overburdened.
Always.
Always. If a judge can save weeks of court time and tens of thousands of pounds of taxpayer money without actually altering the punitive outcome for the defendant, it makes practical sense to do so.
So the lesser charge is effectively sidelined.
The state essentially says, we have enough evidence to convict you of this, but you are already going to prison for a very long time for the other offenses, so we will not expend public resources pursuing this specific accusation.
Okay, here's where it gets really interesting. Because of this highly pragmatic administrative shortcut, the legal system generates a fascinating paradox for the defendant.
A huge paradox.
The judge has openly agreed on the public record that there is enough evidence to prosecute. The state has declared it has the goods. But because the charge is placed into this holding pattern to save time and money, the defendant makes absolutely no admission to this specific charge.
They offer no plea.
None.
They do not confess. Within the strict confines of the legal record for that specific charge, they have admitted to nothing.
Nothing at all.
The state has accused them, the judge has acknowledged the evidence, but the defendant remains entirely silent on the matter.
And because there's no admission, and because the state decided to bypass the trial in the name of efficiency, there is absolutely no verdict recorded against the defendant for this charge.
Technically speaking, yes.
They are technically granted a clean slate for that specific accusation. They exist in a state of absolute legal limbo.
Limbo is the perfect word for it.
They cannot be considered guilty because a court of law never convicted them and a jury never heard the case. But they cannot be considered strictly innocent in the functional sense either, because a judge formally verified that the evidence against them was strong enough to warrant a prosecution.
What is remarkable is how comfortable the legal system is with maintaining this ambiguity. It is a permanent state of to be determined.
The file is open, but the action is suspended.
Yes. And we must be very clear here based on the sources. Allowing a charge to lie on file does not mean the charge is thrown out.
Right, it's not a dismissal.
It is not dismissed. It is not expunged from the record or thrown into an incinerator.
It's essentially placed in cryogenic sleep.
Yes.
It's hibernating in the archives of the court.
Yeah.
Fully formed, but entirely inactive.
The hibernation analogy is perfectly accurate. The documentation details the exact parameters for how these charges are maintained and, more importantly, how they can be brought back to life.
Oh, they can be woken up.
A charge that has been laid on file can theoretically be reinstated and brought to trial at a later date.
Wow.
However, the system recognizes the inherent danger of leaving an active, unproven charge hanging over a citizen's head indefinitely. Because of that, there is a very strict safeguard in place to prevent prosecutorial abuse.
So a prosecutor can't just change their mind a year later, decide they want to punish the defendant further, and unilaterally pull the file out of the drawer to restart the proceedings.
No, absolutely not. The threshold for reinstatement is incredibly high.
What does it take?
It requires high-level judicial authorization. To reinstate a charge that has been laid on file, the prosecution must obtain explicit permission from either the original trial judge who presided over the initial agreement.
Okay, the original judge.
Or they must go higher and secure permission from the Court of Appeal.
Oh, wow, that's a serious hurdle.
It is. This ensures that a charge is only brought out of hibernation if there is a profound, legally justifiable reason to do so, rather than just the arbitrary whim of the state. The barrier to entry for restarting the prosecution is deliberately designed to be steep.
Okay, so far the architecture of this mechanism seems fairly logical.
It does.
It's an administrative tool designed to save court time, save taxpayer money, and streamline the prosecution of defendants who are already facing severe penalties for major crimes.
Very tidy.
Right, it creates an existentially weird gray area, but on paper, it looks like a tidy bureaucratic compromise. But abstract legal concepts rarely stay tidy when they intersect with real-world consequences.
That is the truth.
This seemingly benign administrative tool creates massive friction when it collides with the state's financial enforcement mechanisms.
And this is exactly where the concept moves from being a quirk of courtroom management to a hotly debated point of fundamental law.
Following the money.
Always. The friction originates when this practice intersects with a specific, highly aggressive piece of legislation. The Proceeds of Crime Act 2002.
Let's talk about the Proceeds of Crime Act 2002, or POCA for short. POCA is essentially the state's most powerful weapon for ensuring that crime does not pay.
It's a massive hammer.
The overarching intent of this legislation is to allow the government to confiscate the financial gains, assets, and properties that a convicted individual obtained through their illegal activities.
Strip the profit from the crime.
Exactly. If the state can prove that your wealth was generated by breaking the law, POCA provides the legal framework to seize those assets, bankrupting the criminal enterprise and ensuring the individual cannot enjoy the fruits of their crimes once they are released.
The underlying philosophy of the Proceeds of Crime Act is entirely understandable. The state does not want a convicted fraudster serving a 5-year sentence only to emerge from prison and retire comfortably on the millions of pounds they successfully stole and hid.
Right. That would make the justice system look like a joke.
Precisely. Confiscation proceedings under POCA are rigorous, deep-diving financial investigations into a convicted person's entire economic history. The state evaluates their legitimate income against their actual assets, and the discrepancy is targeted for confiscation.
But the catch, according to our source material, is how the state sometimes calculates that discrepancy. The documentation reveals that charges which have been officially allowed to lie on file have, on occasion, been taken into account during these financial confiscation actions under the Proceeds of Crime Act 2002.
The implications of that are staggering when you break down the legal sequence of events.
It really is.
Think about it. The state is utilizing an accusation, a charge for which the defendant made no admission of guilt, for which no trial was held, and for which no legal verdict was ever reached.
A hibernating charge.
Right. And they are using it as a mathematical basis to calculate how much money they are legally authorized to confiscate from that person.
The state essentially puts the charge in a drawer because it was too expensive or time-consuming to prosecute in front of a jury. But when it comes time to tally up the financial penalties, the state pulls that exact same file out of the drawer and uses it as a receipt to seize assets.
It's wild.
It really is. And this practice introduces us to a significant perspective highlighted in the sources. A legal commentator named David Winch has leveled a profound criticism against this specific use of the Proceeds of Crime Act.
David Winch argues that using charges that lie on file to calculate and confiscate financial gains is a direct, egregious breach of the presumption of innocence.
And this is the crux of the whole debate.
This raises an incredibly important question, one that forces us to examine the very foundational pillars of how modern justice is supposed to operate.
Let's unpack Winch's argument, because it's rooted in a fundamental logical clash. Let's look at the exact status of the defendant regarding the specific charge led on file.
Okay.
They have not confessed.
Wow.
They have not entered a guilty plea.
No plea.
No prosecutor has ever had to present the evidence to a jury. No defense attorney has ever had the opportunity to cross-examine the witnesses, and a judge has never issued a formal guilty verdict.
None of the procedural hurdles of a trial have been cleared.
Right. So in the eyes of the law regarding that specific accusation, the defendant possesses the presumption of innocence.
The presumption of innocence is arguably the most vital concept in English law.
It's the bedrock.
It dictates that a person is innocent until they are definitively proven guilty through a rigorous adversarial legal process.
Keyword being proven.
Proven. It does not state that a person is innocent until a judge quietly agrees there might be enough evidence to convict them if a trial were held.
That's a huge distinction.
A massive one. The standard is absolute proof, verified by a verdict. Winch's commentary is laser-focused on this exact discrepancy. If the state deliberately chose to bypass the mechanism of proving guilt, How can the state then turn around and penalize the individual financially as if that guilt had been definitively established?
The tension here is between the rigorous demands of criminal law and the sweeping powers of asset confiscation. Winch is pointing out that the state is having its cake and eating it too.
Very much so.
They avoid the immense burden, the cost, the risk of a criminal trial by leaving the charge on file. But they still reap the punitive financial rewards by rolling that unproven charge into the proceeds of crime acts calculations.
It effectively bypasses the protective barrier that the presumption of innocence is designed to provide against state power.
And I really want to spend some time on this because it's so philosophically heavy.
It is.
When you bypass that barrier, you are fundamentally altering the definition of what constitutes a punishable offense. Guilt in a legal context is not a feeling, right?
Yeah.
It's not a suspicion. It's not a preliminary evidentiary assessment. Guilt is the final product of a highly controlled, deeply scrutinized procedural marathon.
Exactly. A marathon that tests the evidence against the absolute highest standards.
Right. So by applying financial penalties based on a lie-on-file charge, the state is treating the judge's initial preliminary agreement that there is merely enough evidence to proceed as a completely viable substitute for that entire rigorous process of establishing legal guilt.
And that's a terrifying prospect for civil liberties advocates.
To explore this impartially, as we always do, we have to look at the immense philosophical weight on both sides of this argument.
Yes, because the state isn't just doing this to be vindictive.
No. So on the one side, representing the perspective advocated by David Winch, you have the absolute necessity of procedural justice.
The rule book.
The rule book. The presumption of innocence is not just some bureaucratic hurdle. It is the ultimate shield protecting the individual from the near-infinite resources of the state.
Yeah.
It exists precisely because the state has the power to destroy a person's life, liberty, and finances.
The stakes are the highest they can be.
Therefore, the state must be forced to prove its accusations beyond a reasonable doubt in an open court before it can impose penalties. From this viewpoint, taking someone's assets based on an unproven charge, regardless of how much initial evidence exists, is a subversion of fundamental human rights.
It's like playing a sport, right? Imagine you're on the field, the referee sees a foul, writes it down in his notebook, but never blows the whistle or calls the penalty during the game because he wants to keep the game moving.
It's just to save time.
Right. But then after the game is over, you get fined for that foul.
You'd be furious. You never got to argue the call.
You never had the chance to show you didn't actually commit the foul. That's Winch's argument in a nutshell.
That's a great way to put it. But conversely, you have the utilitarian, deeply pragmatic approach of the state, driven by the mandate of the Proceeds of Crime Act.
The state has a completely different lens on this.
The state's goal is to maximize the efficacy of the justice system and ensure that criminals do not profit from the harm they cause society. The state might argue that the presumption of innocence is heavily guarded in matters of physical liberty, which is exactly why the charge is left on file, rather than resulting in a prison sentence without a trial.
They aren't throwing you in a cell for it.
Right. But regarding financial assets, if a judge has already reviewed the file and confirmed that there is substantive, actionable evidence of a crime, ignoring the financial gains from that specific act allows a known criminal to retain ill-gotten wealth simply due to an administrative shortcut designed to save the public money.
The state is essentially looking at the reality of the situation. You have a defendant who has already admitted to massive systemic criminal behavior. The judge has verified the evidence for the secondary charge.
The paperwork is there.
The paperwork is there. To the state, it might appear to be a massive failure of justice and a betrayal of the public trust to allow a convicted drug trafficker or fraudster to keep hundreds of thousands of pounds simply because the court system was too backlogged to hold a separate trial for every single illicit transaction they engaged in.
The state wants the overall ledger to reflect reality.
They want the real-world accounting to be accurate, regardless of the procedural shortcuts taken in the courtroom. It is a profound clash between the messy administrative realities of a burdened justice system and the rigid, unyielding doctrines of legal philosophy.
Winch represents the belief that foundational principles cannot be compromised for the sake of convenience or utility. You cannot penalize someone based on a race that was never run, even if they were standing at the starting line looking ready to sprint.
And the state represents the belief that the system must function practically in the real world, and that strict adherence to theoretical purity shouldn't provide a financial windfall to admitted criminals.
And it highlights how incredibly delicate the ecosystem of justice really is. The law is not a series of isolated rules. It's an interconnected web.
A very fragile web.
You pull one lever to alleviate pressure in one area, say. You let a charge lie on file to save the court calendar, and inadvertently, you create a massive philosophical loophole on the other side of the system regarding the confiscation of property and civil liberties.
You attempt to streamline courtroom administration, and you end up sparking a fundamental debate about the nature of innocence and state power.
It's all connected.
That interconnectedness is exactly why legal scholars and commentators like David Winch scrutinize these seemingly minor bureaucratic tools so intensely. In the architecture of the law, a small procedural quirk can generate incredibly heavy consequences.
It's a precedent.
Exactly. Tinkering with the edges of the presumption of innocence, even for the seemingly noble goal of seizing criminal assets, establishes a precedent. If the state can confiscate assets based on an unproven accusation that was left on file, it blurs the line between suspicion and conviction.
It creates a fascinating and somewhat terrifying stalemate. The state is driven by an absolute imperative to ensure complete financial restitution and strip the profit motive from organized crime. Commentators like Winch are driven by an absolute imperative to ensure complete, unwavering adherence to the presumption of innocence, regardless of the defendant's broader character.
And right in the middle of this ideological war sits this bizarre legal mechanism.
The charge lying on file, quietly waiting in a drawer, representing neither guilt nor innocence, but wielding the power to empty a bank account.
If we connect this to the bigger picture, analyzing quirks like lie on file provides us with a stark view of the delicate and often incredibly messy balance the justice system is forced to strike every single day.
It's not a perfect machine.
No, the law is frequently idealized as a perfect logical machine that dispenses pure justice. In reality, it is a human system, constrained by budgets, time, and resources.
It have to live in the real world.
It operates in a constant state of tension between efficiency processing cases, managing dockets, focusing on the most severe offenders, and the preservation of fundamental human rights. Understanding how these tools are used and how they are challenged allows us to see the actual mechanics of state power.
It forces us to recognize that justice is often a series of compromises. As we conclude this custom deep dive, I want to leave you with a final lingering thought to mull over. We've spent this time thoroughly examining the severe legal and financial implications of allowing a charge to lie on file. We have debated the philosophical bounds of the presumption of innocence. But consider for a moment the profound psychological and societal impact of this mechanism on the individual.
The human element.
Yes. If a legal system possesses the authority to essentially pause a criminal charge indefinitely, effectively placing a person's presumed innocence into a suspended state inside a file drawer, how does that reality alter their existence?
That's a heavy question.
Even if they avoid prison time for that specific charge, how does that invisible permanent cloud of enough evidence hanging over their head impact their ability to truly rehabilitate and move on in society? If the charge is never brought to trial, never resolved, and never truly incinerated, are they ever fully free from the weight of the state's accusation, even if they never saw the inside of a courtroom to defend themselves against it?
It is a profound, unresolved tension.
It is a heavy, complex thought to carry with you. Thank you so much for joining us on this custom deep dive today. We hope this exploration of English legal limbo and the limits of the presumption of innocence provided you with a deeper understanding of the system. Keep questioning the mechanics of the world around you, keep learning, and we will catch you next time.